Rhode Island Real Estate Exam Prep. Question 1. Under RI real estate law, the real estate license law is administered by the option Director of the RI Department of Business Regulation. Option B, Commission for Human Rights. Option C, RI Association of Realtors Registered. Option D, RI Real Estate Commission. The correct answer is A. Option A, Director of the RI Department of Business Regulation. Explanation. The Director of the RI Department of Business Regulation administers the real estate license law. The other choices are incorrect because the Commission for Human Rights handles fair housing complaints. The RI Association of Realtors Registered is a trade association, and the RI Real Estate Commission is an advisory commission to the Director of the RI Department of Business Regulation. Question 2. Identify how members of the Real Estate Commission selected. Option A, by the State Association of Realtors Registered. Option B, elected by real estate licensees. Option C, by the Governor. Option D, public election. The correct answer is C. Option C, by the Governor. Explanation. RI law provides that the Governor makes appointments to the RI Real Estate Commission for a term of 5 years. Members of the Real Estate Commission are not elected by the public, by the State Association of Realtors Registered, nor by licensees. Question 3. The Director of the RI Department of Business Regulation has the authority to Option A, make and enforce the rules by which all real estate licensees is required to abide. Option B, compose the examination questions on the state exam. Option C, enact the laws that govern real estate licenses. Option D, administer the exams given at the testing sites. The correct answer is A. Option A, make and enforce the rules by which all real estate licensees is required to abide. Explanation. The Director of the RI Department of Business Regulation has the authority to write and enforce the rules and regulations by which all real estate licenses must abide. The other choices are incorrect because the legislature enacts law. The exam questions are written by an independent testing service and reviewed by the Real Estate Commission, and the testing service administers the exams. Question 4. The Director of the RI Department of Business Regulation is permitted to undertake an investigation of a licensee based on the following grounds except Option A, random selection of licensees. Option B, its own initiative. Option C, a motion from the members of the Commission. Option D, a verified written complaint submitted by a disgruntled customer. The correct answer is A. Option A, random selection of licensees. Explanation. The Commission may not initiate random investigations of licensees. There must be a valid reason. Question 5. Under RI real estate law, a real estate license is required for a Option A, resident apartment manager working for an owner if the manager's primary residence is the apartment building being managed. Option B, partnership selling a building owned by the partners. Option C, licensed attorney acting under a power of attorney to convey real estate. Option D, person who employs fewer than 3 apartment leasing agents. The correct answer is B. Option D, person who employs fewer than 3 apartment leasing agents. Explanation. A person who employs any apartment leasing agents requires a license. Anyone holding a power of attorney has the authority to sign the principal's name and does not have to have a real estate license. Question 6. A real estate license is required for which of the following? Option A, executor selling a decedent's building. Option B, not-for-profit real estate referral service. Option C, a company that matches individuals from different parts of the country who want to exchange properties and that assists them in doing so for a fee. Option D, resident manager collecting rent on behalf of a building owner. The correct answer is C. Option C, a company that matches individuals from different parts of the country who want to exchange properties and that assists them in doing so for a fee. Explanation. Matching individuals for a fee or commission requires a real estate license. Question 7. Under a RI law, any person other than the owner who sells a single cooperative unit is required to. Option A. There are no special licensing requirements for a person selling a single cooperative unit. Option B. Be licensed as a securities broker. Option C. Be approved by the Securities and Exchange Commission. Option D. Have his or her securities license endorsed by the Real Estate Commission. The correct answer is B. Option B. Be licensed as a securities broker. Explanation. The sale of a single WAP unit is the sale of WAP stock and the transfer of the proprietary lease. Real property ownership rights are not involved, and therefore, to conduct security exchanges, the non-owner selling the stock must have a securities license. Question 8. Under a RI licensing law, a partnership, association, or corporation will be granted a license only if. Option all papers are filed with the Secretary of State. Option B, the broker retains a current license. Option C, every member and officer actively participating in the brokerage business has a broker's license. Option D, the brokerage business has paid a one-time fee to the guarantee fund. The correct answer is B. Option B, the broker retains a current license. Explanation. All members must have a license, one of which is a broker's license. Question 9. Engaging in the real estate business consists of acting for another for a fee in the following activities except. Option A, selling real estate. Option B, managing real estate. Option C, reselling a mobile home. Option D, collecting rent for the use of real estate. The correct answer is C. Option C, reselling a mobile home. Explanation. Reselling a mobile home does not require a real estate license unless land is part of the sale, because in our RI, mobile homes are considered personal property. Selling or managing real estate for another is considered real estate activities for which a license is required. Question 10. If engaged in real estate activities, which of the following are exempt from the real estate licensing requirement? Option A, appraisers. Option B, associations, partnerships, corporations. Option C, real property rental managers. Option D, attorneys at law. The correct answer is D. Option D, attorneys at law. Explanation. Attorneys at law are exempt from licensing requirements. If engaging in real estate activities, associations, partnerships, and appraisers must have a real estate license. Question 11. The office manager for a local real estate firm is responsible for the following activities: coordinating the flow of paperwork through the office, preparing forms and advertising copy, and hiring and supervising clerical personnel. The office manager is Option A, required to have a broker's license. Option B, violating the license law. Option C, required to have a salesperson's license. Option D, exempt from real estate licensing requirements. The correct answer is D. Option D, exempt from real estate licensing requirements. Explanation. The office manager is performing non-real estate activities and is therefore exempt from licensing requirements. Question 12. Under Rhode real estate law, applications for any real estate license is required to: Option A, be accompanied by a sworn statement attesting to the applicant's character. Option B, be submitted before May 31 of each year. Option C, contain a picture of the applicant. Option B, be completed and submitted to the RI Department of Business Regulation before taking the written exam. The correct answer is B. Option B, be completed and submitted to the RI Department of Business Regulation before taking the written exam. Explanation. An application must be completed and submitted to the RI Department of Business Regulation before taking the test, which is given on an ongoing basis throughout the year. The Commission does not require a photo, and sworn statements are not required to take the test. Question 13. Under RI real estate law, the following are requirements for obtaining a broker's license, etc. Option A, being of good moral character. Option B, having been actively engaged as a licensed salesperson for at least 3 years. Option C, having successfully completed 90 hours of approved real estate courses. Option D, being at least 21 years of age. The correct answer is B. Option B, having been actively engaged as a licensed salesperson for at least 3 years. Explanation. To obtain a broker's license, one must be licensed for 2 years, successfully complete 90 hours of approved real estate courses, be at least 21 years of age, and be of good moral character. Question 14. A person successfully completed her real estate CEU requirement on November 1, 2000. Identify the latest date on which she is permitted to apply for license renewal for a salesperson's license. Option A, October 31, 2001. Option B, April 30, 2002. Option C, December 31, 2000. Option D, November 1, 2002. The correct answer is B. Option B, April 30, 2002. Explanation. All RI licenses expire on April 30 of every given numbered year. Question 15. 3 weeks before N begins his real estate license class, he offers to help his neighbor sell her house. The neighbor agrees to pay N a 5% commission. An offer is accepted while N is taking the class, and the closing takes place on the day before N passes the examination and receives his salesperson's license. The neighbor refuses to pay N the agreed commission. Can N sue to recover payment? Option A, yes, because N was formally enrolled in a course of study intended to result in a real estate license at the time an offer was procured and accepted. The commission agreement is binding. Option B, yes, while the statute of frauds forbids recovery on an oral agreement for the conveyance of real property, RI law permits enforcement of an oral commission contract under these facts. Option C, no, state law prohibits lawsuits to collect commissions unless the injured party is a licensed broker and the license was in effect before the agreement was reached. Option D, no, in RI, a real estate salesperson is required to work in a permanent office in which his or her license is displayed in order to collect a commission from a seller. The correct answer is C. Option C, no, state law prohibits lawsuits to collect commissions unless the injured party is a licensed broker and the license was in effect before the agreement was reached. Explanation. N cannot sue to recover payment because the injured party must have had an active license at the time the agreement was reached. Question 16. Which statement persons is required to have a real estate license in order to transact business? Option A, the superintendent of a large apartment building who shows apartments to prospective tenants as part of his or her regular duties. Option B, A person who owns a sixplex and personally manages the building, collects rents, and shows the apartments to prospective tenants. Option C. A person who negotiates the sales of entire businesses, including their stock, equipment, and buildings for a promised fee. Option D. A person who has his or her parents' written authority to negotiate the sale of the parent's residence. The correct answer is C. Option C. A person who negotiates the sales of entire businesses, including their stock, equipment, and buildings for a promised fee. Explanation. Anyone who is engaged in a real estate activity, such as negotiating the sale of a building along with the personal property, must have a real estate license. The other choices are incorrect because selling personal property does not require a license. Owners are not required to obtain real estate licenses to manage their own properties, and if a person has written authority to sign on behalf of another, he or she need not. Question 17. An applicant for a real estate license in RI is required to: Option A, be at least 21 years old. Option B, not have been convicted of a felony. Option C, show proof of passing the license examination any time up to 6 months prior to the application. Option D, have completed at least 2 years of college. The correct answer is B. Option B, not have been convicted of a felony. Explanation. An applicant must not have been convicted of a felony. The applicant must be at least 18 years of age. Question 18. An unlicensed individual who engages in activities for which a real estate license is required is subject to which of the following penalties for the first offense? Option A, fine not to exceed $5,000. Option B, fine not to exceed $500, 1 year imprisonment, or both. Option C, civil penalty not to exceed $5,000 and a mandatory prison term not to exceed 5 years. Option D, civil penalty of $5,000 in addition to other penalties provided by law. The correct answer is B. Option B, fine not to exceed $500, 1 year imprisonment, or both. Explanation. The maximum fine is $500, 1 year in prison for the first offense, or both. Consequences for subsequent offenses are $500 to $1,000 fines and for 2 years in prison per offense. Question 19. Identify when real estate salesperson's license is expired in RI. Option A, April 30 of every even numbered year. Option B, March 31 of every odd numbered year. Option C, January 31 of every odd numbered year. Option D, December 31 of the 3rd year of licensure. The correct answer is A. Option A, April 30 of every even numbered year. Explanation. Real estate salesperson's licenses expire in RI on April 30 of every even numbered year. Question 20. To renew a license in RI, a salesperson is required to: Option only pay a fee of $80. Option B, have completed 24 hours of continuing education in the last 2 years. Option C, be actively participating in the real estate business. Option D, have completed 6 hours of continuing education in the last 2 years, 3 hours in real estate law, and 3 hours in fair housing. The correct answer is B. Option B, have completed 24 hours of continuing education in the last 2 years. Explanation. The licensee must take 24 hours of continuing education within the last 2 years prior to renewal in order to renew his or her real estate license. Question 21. A licensee who allows his or her license to be inactive has how long to reinstate the license without re-examination? Option A, 1 year from the last June 23 he or she had an active license. Option B, there is no free time. Option C, up to 1 year. Option D, no more than 2 years. The correct answer is C. Option C, up to 1 year. Explanation. A licensee is given a 1-year inactive period in which to become active after his or her license has become inactive. Question 22. Under Rhode Island real estate law, licenses are renewed. Option B, on April 30th of each year. Option B, every 2 years in the month of the licensee's birthday. Option C, on April 30th of every even-numbered year. Option D, annually, in the month issued. The correct answer is C. Option C, on April 30th of every even-numbered year. Explanation. In Rye, licensees are renewed on April 30th every even-numbered year. Question 23. After the first renewal, what is required to renew a salesperson's real estate license? Option A, 18 hours of home study. Option B, 12 approved course hours of continuing education. Option C, 3 12-hour classes for listing, buying, and ethics. Option D, there are no mandatory requirements. The correct answer is B. Option B, 12 approved course hours of continuing education. Explanation. Our Rye law provides that to renew a salesperson's real estate license, the applicant must successfully complete 12 continuing education course hours from the Real Estate Licensing Division's list of approved list of courses. Question 24. Under our Rye real estate law, an unlicensed real estate assistant is permitted to perform the following activities except: Option A, compute commission checks. Option B, prepare and distribute flyers and promotional materials. Option C, assemble legal documents required for closing. Option D, explain clauses on preprinted contract documents to prospective buyers. The correct answer is D. Option D, explain clauses on preprinted contract documents to prospective buyers. Explanation. Only licensees may explain and fill in blanks on preprinted contract forms. A person does not have to be licensed to write advertising under the direction of a licensee. Question 25. Personal real estate assistants in RI. Option A is required to be licensed. Option B is permitted to insert factual information into form contracts under the employing broker's supervision and approval. Option C is permitted to independently host open houses and home show booths. Option D is required to be unlicensed individuals. Licensees is required to be either salespeople or associate brokers. The correct answer is B. Option B is permitted to insert factual information into form contracts under the employing broker's supervision and approval. Explanation. Personal assistants may be licensed in order to perform more services for the licensee who hired them. Some assistants are unlicensed, performing only ministerial duties. Question 26. A broker's unlicensed assistant worked late nights and weekends to help ensure the successful closing of a difficult transaction. The assistant's extra work included making several phone calls to the prospective buyers, encouraging them to accept the seller's counteroffer. Largely because of the assistant's efforts, the sale went through with no problem. The broker now wants to pay the assistant a percentage of the commission because the assistant has really earned it. Under RI license law, the broker is permitted to: Option A, not pay the assistant a cash commission, but is permitted to make a gift of tangible personal property. Option B, compensate the assistant in the form of a commission under the circumstances described here. Option C, pay a commission to the assistant only if the assistant is an independent contractor. Option D. Not pay a commission to the assistant under the facts presented here. They are both in violation of rules regarding unlicensed assistants. The correct answer is D. Option D. Not pay a commission to the assistant under the facts presented here. They are both in violation of rules regarding unlicensed assistants. Explanation. Both the broker and assistant are in violation of RI license law because unlicensed assistants are not permitted to perform the described services, and commissions paid to unlicensed personnel are not allowed. Question 27. If a person obtained the RI reciprocal real estate broker's license, he or she is required to: Option A. Take all education course requirements in RI. Option B. Establish a principal place of business in RI or be licensed under a resident RI broker. Option C. File the power of attorney with the director of the RI Department of Business Regulation. Option D. Be licensed as a broker or salesperson in any reciprocal licensure state. The correct answer is C. Option C. File a power of attorney with the director of the RI Department of Business Regulation. Explanation. To obtain a RI reciprocal real estate broker's license, an applicant must file a power of attorney with the director of the RI Department of Business Regulation. The applicant must operate an office in the state of his or her residence. Question 28. What is required to a non-resident license applicant file with the director of the RI Department of Business Regulation? Option A. Corpus delicti. Option B. A certificate of specific performance. Option C. Power of attorney naming the director of the RI Department of Business Regulation as the applicant's attorney, in fact, with respect to RI license law. Option D. Copy of his or her birth certificate. The correct answer is C. Option C. Power of attorney naming the director of the RI Department of Business Regulation as the applicant's attorney, in fact, with respect to RI license law. Explanation. A non-resident license applicant must file the power of attorney with the director of the RI Department of Business Regulation. Question 29. Which statements regarding the RI Real Estate Commission is not true? Option A. The examinations that is required to be taken by all applicants for real estate licensing are administered by an independent testing company. Option B. The director of the RI Department of Business Regulation makes and enforces the rules by which all real estate licensees is required to abide. Option C. Members of the commission are selected by the State Association of Realtors registered. Option D. The operation of the commission's activities is administered by an executive director specifically hired for that purpose. The correct answer is C. Option C. Members of the commission are selected by the State Association of Realtors registered. Explanation. The State Association of Realtors registered does not select members of the RI Real Estate Commission. The Commission makes and enforces license law rules and oversees the examinations given by an independent testing company. Question 30. The on-site property manager for Acme Apartments is responsible for negotiating leases for the apartments. In this position, the on-site manager. Option A is exempt from the licensing requirements. Option D is required to have a salesperson's license. Option C is violating the license law. Option D is required to have a broker's license. The correct answer is A. Option it is exempt from the licensing requirements. Explanation. On-site property managers are specifically exempt from the licensing requirements. Question 31. All of the following are exempt from the provisions of the RI license law except N. Option A. Individual who receive compensation for procuring prospective buyers or renters of real estate. Option B, resident lessee who receives the equivalent of 1 month's rent as a finder's fee for referring a new tenant to the owner. Option C, property owner who sells or leases his or her own property. Option D, individual who is employed as a resident property manager. The correct answer is A. Option A, individual who received compensation for procuring prospective buyers or renters of real estate. Explanation. Anyone receiving compensation for finding buyers or tenants must first hold a real estate license. Anyone selling or renting his or her own property does not need a license. Question 32. An individual wants to sell her own house. Which statements is true? Option A. In Rye, anyone who sells real property is required to first have a real estate license issued by the Rye Department of Business Regulation. Option B. She is permitted to sell her house without obtaining a real estate license only if she is a licensed attorney. Option C. The individual is permitted to obtain a temporary real estate license in order to legally sell her house. Option D. She does not need a real estate license to sell her house herself. The correct answer is D. Option D. She does not need a real estate license to sell her house herself. Explanation. Anyone selling or renting his or her own property does not need a license to do so. The owner does not have to be an attorney nor receive permission from anyone. Question 33. Which statement is a requirement to obtain a real estate salesperson's license in Rye? Option A. Successful completion of an examination of general principles of real estate and Rye real estate license law. Option B. Successful completion of 12 credit hours of real estate law, investments, finance, and appraisal. Option C. An associate degree or certificate in real estate from an accredited college, university, or proprietary school. Option D. United States NRI citizenship. The correct answer is A. Option A. Successful completion of an examination of general principles of real estate and RI real estate license law. Explanation. One requirement for a salesperson's license is the successful completion of an examination on general real estate principles and RI license law. No college is required, nor is United States or RI citizenship. Question 34. Which statement situations would satisfy the biannual CU requirement in RI? Option A. Participation in a 12-hour course on using spreadsheet programs effectively in a real estate office, offered by a local community college. Option B. Attending approved CU courses that result in the accumulation of 24 hours of classroom participation. Option C. Attending a 6-hour course on managing agricultural property, offered by an approved CEU sponsor. Option D. Teaching a pre-license course several evenings a week. The correct answer is B. Option B. Attending approved CEU courses that result in the accumulation of 24 hours of classroom participation. Explanation. 12 hours of approved CEU courses are required to satisfy the biannual CEU requirement in RI. Question 35. RI real estate licenses. Option expire on April 30 of every even numbered year. Option B are granted in perpetuity. Option C do not need to be renewed unless previously revoked. Option D expire annually on April 30. The correct answer is A. Option expire on April 30 of every even numbered year. Explanation. All RI real estate licenses expire on April 30 in even numbered years only. Question 36. Identify the expiration date of every salesperson's license in RI. Option A. October 31 of each hot numbered year. Option B, January 31 of every even-numbered year. Option C, April 30 of each even-numbered year. Option D, every other anniversary date of the individual salesperson's license. The correct answer is C. Option C, April 30 of each even-numbered year. Explanation. The expiration date of every salesperson's license in RI is April 30 of each even-numbered year. Question 37. A broker who holds a RI license by reciprocity, but whose home state is Connecticut, will be exempt from the requirement that he or she maintain a definite place of business in RI if the following factors are met except: Option A, if the broker files a written power of attorney appointing the director of the RI Department of Business Regulation as his or her RI agent for service of process, submits to the RIPER jurisdiction, and agrees to abide by the provisions of the License Act. Option B, if at least one RI licensee is employed by the broker, either as a salesperson or associate broker. Option C, if an active broker's license in the state of Connecticut is maintained by the broker. Option D, if the broker maintains an office in Connecticut. The correct answer is B. Option B, if at least one RI licensee is employed by the broker, either as a salesperson or associate broker. Explanation. The broker does not have to employ any salespeople. The broker must, however, maintain an office and an active broker's license in his or her home state, and the broker must file a written power of attorney appointing the director of RI Department of Business Regulation as his or her RI agent for service of process. Question 38. A person is required to be licensed as a real estate broker or salesperson if that person is: Option A, engaging in the real estate business. Option B, selling his or her house. Option C, buying a house for his or her personal use. Option D, constructing houses. The correct answer is A. Option A, engaging in the real estate business. Explanation. Anyone engaging in the real estate business for the benefit of another must first hold a real estate license. Individuals may buy, sell, or build their own houses without a real estate license. Question 39. A licensed broker procures a ready, willing, and able buyer for his or her seller principal. The seller accepts the buyer's offer in writing, then experiences a change of heart and withdraws the acceptance. In the situation, the broker: Option A, is entitled to collect a commission. Option B, is permitted to sue the buyer. Option C, is permitted to retain a deposit as commission. Option D, is without recourse because the transaction was never completed. The correct answer is A. Option A, is entitled to collect a commission. Explanation. The broker earned the commission since the seller accepted the offer. However, the broker will have to pursue the seller for the commission in court. The deposit must be returned to the buyer, and the broker cannot take his or her commission from it. Question 40. A seller's listing agreement has expired and the seller lists with a different brokerage firm. Jim, the original listing agent, now has a buyer interested in the seller's property. Jim. Option A, is a dual agent. Option B, cannot disclose information about the physical condition of the property to the buyer. Option C, cannot disclose offers received on the seller's property while it was listed with him to the buyer. Option D, cannot represent the buyer. The correct answer is C. Option C, cannot disclose offers received on the seller's property while it was listed with him to the buyer. Explanation. Confidential information must remain confidential forever, but agents must always disclose information about the physical condition of the property. The original listing agent is now free to represent the buyer since the original agent no longer has an agency relationship with the seller. Question 41. A real estate salesperson has been working with buyers. After helping them negotiate for their dream home, the buyers ask the salesperson if she can help them secure a mortgage. The salesperson knows a lender that pays a fee for referring purchasers to them. Should the salesperson refer the buyers to this lender? Option A. Yes, if the lender offers the market's best interest rates and terms. Option B. No, because this would be an unwise referral. Option C. Yes, if the salesperson discloses the referral fee to the sellers. Option D. Yes, if the salesperson and the buyers have previously entered into a written buyer agency agreement. The correct answer is B. Option B. No, because this would be an unwise referral. Explanation. This is an unwise referral. The salesperson should not refer her buyers to this lender since salespeople can only receive compensation from their employing brokers. Question 42. Under our real estate law, an exclusive right to buy contract. Option A requires the signature of the principal only. Option B is equivalent to a listing agreement. Option C is required to be indicated as such in the buyer agency agreement. Option D is illegal. The correct answer is C. Option C is required to be indicated as such in the buyer agency agreement. Explanation. Buyers can enter into an exclusive right to buy agreement, but it must be clearly identified. Question 43. Buyer brokerage contracts are RI. Option A is required to be in writing to be enforceable. Option B are not regulated under the license laws. Option C is required to be on specific forms. Option D are illegal. The correct answer is A. Option A is required to be in writing to be enforceable. Explanation. The buyer brokerage contract is an employment contract and must be in writing to be enforceable. Question 44. All of the following provisions are included in the RI real estate license law regarding listing agreements, except the provision that Option A. The seller is required to receive a true copy of the listing agreement after signing it. Option B. A listing agreement is required to be in writing and signed by both broker or authorized representative and seller. Option C. A listing agreement is required to state the exact fee the broker will earn. Option D. A listing agreement is required to be accompanied by a qualified expert's report of the property's condition. The correct answer is D. Option D. A listing agreement is required to be accompanied by a qualified expert's report of the property's condition. Explanation. The agent does not have to include an expert's report on the property condition as part of the listing agreement. The listing agreement must state the exact brokerage fee, be in writing and signed by both broker or representative and seller. Question 45. A seller is required to give a buyer a property condition disclosure report in the following transactions except Option A. If the buyer has lived on the property as a tenant. Option B. A sale of commercial property. Option C. When the seller is not assisted by a licensed real estate agent. Option D. If the seller has not resided on the property in the last year. The correct answer is B. Option B is sale of commercial property. Explanation. The law does not mandate a property condition disclosure report with the sale of commercial property. Seller property disclosure forms are required in the transfer of 1 to 4 dwelling units. Question 46. Seller property condition disclosures is required to be delivered to the buyer. Option A. Prior to closing. Option B. Prior to the buyer's making a written offer. Option C. At the time of the home inspection. Option D. At the time that the seller agrees to the offer. The correct answer is B. Option B, prior to the buyer's making a written offer. Explanation. The form must be delivered before the buyer makes an offer so that the buyer can make an informed offer. Question 47. A seller has no knowledge of any plumbing system problems on the property she is selling. In actuality, however, the pipes are seriously corroded and will need to be replaced soon. In the seller property condition disclosure, when responding to whether the seller has any knowledge of plumbing system problems, she should respond. Option A, no. Option B, yes. Option C, the seller would not be required to respond to this question. Option D, unknown. The correct answer is A. Option A, no. Explanation. The seller should say no since she has no knowledge of any problems with the system at the present time. Question 48. Under RI real estate law, when a broker is listing a home and asks the seller to complete a property condition disclosure, which of the following statements is true? Option A. An agent should not give the seller any advice regarding which property conditions to disclose and which to ignore. Option B. Seller disclosure of known property conditions is required by RI statute. Option C. The standard disclosures cover a narrow range of structural conditions only. Option D. The disclosures are optional, and the seller is permitted to avoid liability by refusing to make any disclosures about the condition of the property. The correct answer is B. Option B. Seller disclosure of known property conditions is required by RI statute. Explanation. Property disclosures must be made for the sale of all 1 to 4 dwelling units. Required disclosures cover a wide range of potential problems, and the agent should encourage the seller to be honest and disclose all known problems. Question 49. A salesperson represents a seller in a transaction. When prospective buyers ask to look at the property, the salesperson is required to: Option A, inform them, either orally or in writing, that the salesperson represents the seller's interest. Option B, tell them that they is required to first enter into a buyer representation agreement with another licensee. Option C, inform them in writing that the salesperson represents the seller's interests. Option D, show them the property without making any disclosures about the salesperson's relationship with the seller, because such disclosure would be a violation of the salesperson's fiduciary duties. The correct answer is C. Option C, inform them in writing that the salesperson represents the seller's interests. Explanation. The agent must clearly indicate that he or she represents the seller's best interests. Buyers do not have to be represented to work with the seller's agent. Question 50. 5 years ago, Unit 5B in a condominium community was the site of a brutal and highly publicized murder. The unit was sold to an elderly woman who contracted the AIDS virus in a blood transfusion and died in the unit last year. As the agent for the woman's estate, what are your disclosure responsibilities to prospective purchasers of Unit 5B? Option A. You are specifically prohibited by law from disclosing either event. Option B. You is required to disclose both the murder and the AIDS-related death. Option C. You do not need to disclose the murder, but she was required to disclose the AIDS-related death. Option D. You are specifically relieved of liability for non-disclosure of either by the RI or Real Estate Sales Disclosures Law. The correct answer is D. Option D. You are specifically relieved of liability for non-disclosure of either by the RI Real Estate Sales Disclosures Law. Explanation. Neither must be disclosed. State law does not cover stigmatized properties, and federal fair housing laws prohibit discussion of the AIDS-related death. Question 51. A broker took a listing for a small office building Because the property is in excellent condition and produces a good, steady income, the broker's salesperson has decided to purchase it as an investment. If the broker's salesperson wishes to buy this property, the salesperson is required to Option obtain permission from the RI Real Estate Commission. Option B, have some third party purchase the property on the salesperson's behalf so that the owner does not learn the true identity of the purchaser. Option C, inform the owner in writing that the salesperson is a licensee before making an offer. Option D, resign as the broker's agent and make an offer after the owner has retained another broker. The correct answer is C. Option C, inform the owner in writing that the salesperson is a licensee before making an offer. Explanation. The salesperson will have to inform the owner in writing that the salesperson is a licensee before making the offer. The salesperson does not have to resign nor obtain permission from the RI Real Estate Commission. Question 52. 6 months after a buyer bought a house, the roof leaked during a rainstorm. When the house was listed, the seller told the broker that the roof leaked, but they agreed not to tell any prospective buyers. The broker claims that the buyer did not ask about the roof. Under these facts, the buyer. Option A, can sue the broker since disclosure is required by license law. Option B, cannot sue the broker under the license law. Option C, can sue the seller under license law. Option D, cannot do anything because the leaking roof could have been discovered by inspection. The correct answer is A. Option A, can sue the broker since disclosure is required by license law. Explanation. The buyer can sue the broker, but cannot sue the seller under license law. The broker is required by law to disclose any fact that would materially affect the buyer's decision to make an offer. Question 53. The real estate licensee is required to give the agency disclosure statement to prospective purchasers' tenants. Option at the closing table. Option B, before they are shown any properties. Option C, at an open house. Option D, before any offers to purchase or lease are prepared or presented. The correct answer is D. Option D, before any offers to purchase or lease are prepared or presented. Explanation. The buyer or prospective tenant should be given an agency disclosure statement before any offers to purchase or lease are prepared or presented. Question 54. All of the following are exempt from the Property Disclosure Act except A. Option A, foreclosure sale. Option B, sale by an uncle to his niece. Option C, sale by a real estate licensee of a 2-unit residential property. Option D, conveyance of a primary residence from one former spouse to another under divorce settlement agreement. The correct answer is C. Option C, sale by a real estate licensee of a 2-unit residential property. Explanation. A 2-unit residential property is covered by the Disclosure Act. Foreclosures, sales between close family members, and a conveyance from one spouse to another and a divorce are all exempt from the Disclosure Act. Question 55. A licensed salesperson obtains a listing. Several days later, a salesperson meets prospective buyers at the property and tells them, "I am a listing agent for this property, and so I'm very familiar with it." Under these circumstances, the salesperson. Option A, has failed to properly disclose his or her agency relationship. Option B, has created a dual agency, which is a violation of RI regulations. Option C, has properly disclosed his or her agency relationship with the seller. Option D, is in violation of RI regulations because the listing belongs to the broker. The correct answer is A. Option A, has failed to properly disclose his or her agency relationship. Explanation. The statement is an inadequate disclosure. Agency representation is not a disclosure about the property, but rather the duties and obligations to a client and a customer. Question 56. A real estate broker representing a seller knows that the property has a cracked foundation and that its former owner committed suicide in the kitchen. The broker is required to disclose option of both facts. Option B, neither fact. Option C, the suicide only. Option D, the cracked foundation only. The correct answer is D. Option D, the cracked foundation only. Explanation. The broker must disclose the cracked foundation, but discussing the suicide could constitute a breach of duty to the client. Question 57. A broker has entered into a listing agreement with a seller. Another broker, who has been working with a buyer as a customer, learns of the property through the MLS. Typically, the second cooperating broker would represent option, the buyer as a subagent. Option B, the buyer as an agent. Option C, neither buyer nor seller. Option D, the seller as a subagent. The correct answer is D. Option D, the seller as a subagent. Explanation. Typically, the second cooperating broker would represent the seller as a subagent. Question 58. A broker decides to sweeten an MLS listing for a property by making a blanket offer of subagency. Is the broker's action acceptable? Option A, no, because subagency relationships in RI is permitted to be created only by a specific agreement between the parties. Option B, yes, because RI law permits the creation of subagency relationships only through multiple listing services. Option C, yes, because a subagency relationship is permitted to be created by either a blanket offer in an MLS or through a specific agreement between parties. Option D, no, because subagency is illegal under Article Roman 4 of the RI Real Estate License Law. The correct answer is A. Option A, no, because subagency relationships in RI is permitted to be created only by a specific agreement between the parties. Explanation. The broker may not make a blanket offer of subagency because subagency relationships may be created only with a specific agreement between the parties. Question 59. A buyer who is a client of a broker wants to purchase a house that the broker has listed for sale. Which statements is true? Option A. The seller and buyer is required to be informed of the situation and agree to the broker's representation of both of them. Option B. The buyer should not have been shown a house listed by the broker. Option C. The broker should refer the buyer to another broker to negotiate the sale. Option D. If the listing salesperson and selling salesperson are two different people, there is no problem. The correct answer is A. Option A. The seller and buyer is required to be informed of the situation and agree to the broker's representation of both of them. Explanation. The seller and buyer must be informed of the dual agency situation and agree to the broker's representation of both of them. Question 60. Under RI real estate law, the following would be grounds for revoking a broker's license except option of being convicted of a felony. Option B, agreeing with the seller to accept a listing for more than the normal commission rate. Option C, advertising in a newspaper that he or she is a member of the RI Association of Real Estate Professionals when in fact he or she is not. Option D, depositing escrow money in his or her personal checking account. The correct answer is B. Option B, agreeing with the seller to accept a listing for more than the normal commission rate. Explanation. Commission rates are always negotiable between the seller and the broker. Activities for which a license may be revoked include conviction of a felony, false advertising, and commingling of funds. Question 61. The Commission has the power to revoke a salesperson's license if the salesperson Option A deposits a buyer's down payment into his or her own bank account. Option B enters into an exclusive listing contract. Option C attempts to represent a buyer. Option D declines to represent a real estate broker other than his or her employer after obtaining the employer's consent. The correct answer is A. Option A deposits the buyer's down payment into his or her own bank account. Explanation. Commingling of personal and clients' funds is a prohibited practice. The other choices are incorrect because a salesperson may represent only one broker at a time. Buyers may be represented, and most real estate brokers prefer an exclusive listing agreement. Question 62. Under our real estate law, a broker is permitted to have his or her license suspended or revoked for the following actions, except Option A being declared mentally incompetent. Option B displaying a for sale sign on a property without the owner's consent. Option C helping another person cheat on the licensing examination. Option D depositing earnest money into the firm's escrow account. The correct answer is D. Option D depositing earnest money into the firm's escrow account. Explanation. Depositing earnest money into the firm's escrow account is proper conduct. Grounds for suspension or revocation include being declared mentally incompetent, cheating on the licensing examination, and displaying a for sale sign on a property without the owner's consent. Question 63. For which of the following acts is the RI Department of Business Regulation required to suspend or revoke a licensee's license? Option A. Failing to provide information requested by the Office of Banks and Real Estate within 30 days of the request as part of a complaint or audit procedure. Option B. Failing to perform as promised in a guaranteed sales plan. Option C. Having been found liable in a civil trial for illegal discrimination. Option D. Commingling clients' money or property with his or her own. The correct answer is C. Option C. Having been found liable in a civil trial for illegal discrimination. Explanation. The RI Department of Business Regulation is specifically mandated by state license law to revoke the license if a licensee has been found liable in a civil trial for illegal discrimination. The other situations, failing to perform as promised in a guaranteed sales plan, commingling money, and failing to provide information to the Office of Banks and Real Estate within 30 days, may be grounds for suspension, but it is not. Question 64. Which statement actions is legal and not a violation of license law? Option A. Standing in the hallway outside the testing room and offering employment to new licensees as soon as they receive their passing score at the testing center. Option B. Encouraging a seller to reject an offer because the prospective buyer is a Methodist. Option C. Advertising that individuals who attend a promotional presentation will receive a prize without mentioning that they will also have to take a day trip to a new subdivision site. Option D. Placing a for sale sign in front of a house after asking the seller's permission and receiving written permission to do so. The correct answer is D. Option D. Placing a for sale sign in front of a house after asking the seller's permission and receiving written permission to do so. Explanation. The broker must always have permission before erecting a sign. Brokers are not permitted, however, to solicit information or offer employment at the testing site, encourage a decision based on religious grounds, or fail to make full disclosures of all conditions of a promotion. Question 65. If a broker tells the lender that the sales price on a property is something above its actual sales price, the Option A. Broker can lose his or her license and be fined. Option B. Broker has done nothing wrong as long as the appraisal substantiates this price. Option C. Buyer is likely to receive an interest rate break. Option D. Buyer can receive a higher mortgage amount. The correct answer is A. Option: a broker can lose his or her license and be fined. Explanation: the broker can lose his or her license and be fined. Brokers are not to be parties to dual contracts for the purpose of obtaining a larger loan. Question 66. Salesperson J.H. paid the local telephone company to list her name in the directory under the real estate heading as J.H. Real estate salesperson, residential property my specialty. J.H. is also required to include option and the expiration date of her license. Option B, the name of her employing broker. Option C, her license number. Option D, her street address. The correct answer is B. Option B, the name of her employing broker. Explanation: all advertising is in the employing broker's name, and therefore J.H. must indicate the name of her employing broker. Question 67. A broker who wishes to place a for sale sign on a listed property is required to first: option: obtain the property owner's consent. Option B, get the neighbor's permission. Option C, list the property. Option D, sell the property. The correct answer is A. Option: obtain the property owner's consent. Explanation: after obtaining the property owner's permission, the broker may erect a for sale sign on the property. Question 68. When advertising real property, real estate licensees, option A is required to include the name of a licensed real estate broker in all ads placed. Option B is required to identify the owner of the property. Option C is permitted to state only the licensee's box number or street address. Option D is permitted to simply give a telephone number to call for more information. The correct answer is A. Option that is required to include the name of a licensed real estate broker in all ads placed. Explanation: in order to avoid a blind ad, all advertising must be made in the name of the employing broker, not the licensee. A telephone number is not sufficient. Question 69. A real estate salesperson decides to sell his or her own property without using a broker. When advertising the property, the salesperson: option A is required to disclose the name, address, and phone number of his or her employing broker. Option B does not need to disclose license status in advertisements if acting as a private citizen. Option C is required to disclose the fact that he or she is a real estate licensee. Option D is prohibited from selling his or her own home in this manner by license law. The correct answer is B. Option B does not need to disclose license status in advertisements if acting as a private citizen. Explanation: when acting as a private citizen, the salesperson need not disclose license status in advertising. The licensee must disclose license status to the serious buyer prior to an offer to purchase being signed. Question 70. A broker has developed a website advertising the broker's office. What, if anything, does the broker need to include? Option A: license number of brokerage and list of current active licensees. Option B: name and address of home office in states in which the brokerage holds licenses. Option C: there is no RI requirement for specific disclosures in this situation. Option D: names of active licensees, addresses, and phone numbers. The correct answer is B. Option B: name and address of home office in states in which the brokerage holds licenses. Explanation: each screen must include the name of the brokerage, home office address, and the states in which the brokerage holds licenses. However, if the brokerage is a member of a national franchise and is independently owned and operated, this must be stated in the website. Question 71. A salesperson has developed a website on the internet. What, if anything, is required to the salesperson include? Option A. There is no need for additional disclosures. Option B. Name and location of office that holds the salesperson's license and list of states in which salesperson is licensed. Option C. Names of all licensees in broker's office and the states in which they are licensed. Option D. Name of home office of company that holds salesperson's license and list of states in which company is licensed. The correct answer is B. Option B. Name and location of office that holds the salesperson's license and list of states in which salesperson is licensed. Explanation. Each screen must include the name and location of the salesperson's office and a list of states in which the salesperson is licensed. The licensee does not have to name other licensees or identify the home office. Question 72. Listing is based on a net price R. Option A, more profitable because no minimum is set on the amount of commission collectible. Option B, legal and are right as long as the seller agrees. Option C, illegal and are right at any time. Option D, permissible with approval of the commission. The correct answer is C. Option C, illegal and are right at any time. Explanation. Net listings are illegal because of potential conflict of interest for the broker. Question 73. A seller told the RI broker that she wanted to clear $50,000 when she sold her house. The broker accepted the listing and sold it for $160,000. He gave $50,000 to the seller and kept the rest. Which statement is correct? Option A. The broker's commission exceeds statutory and NAR guidelines. Option B. The broker accepted an illegal net listing. Option C. The broker should have given the seller a better appraisal of the value of her house. Option D. As the seller's agent, the broker had a duty to sell the house for as is required to as possible. The correct answer is B. Option B. The broker accepted an illegal net listing. Explanation. The broker accepted an illegal net listing. This is a good example of the conflict of interest that an illegal net listing provokes since the broker was not working in the best interest of his client. Question 74. Under our real estate law, real estate commissions are: Option A, set by the Real Estate Commission. Option B, set by law. Option C, negotiable between the seller or buyer and buyer's brokerage and broker. Option D, determined by local groups of brokers. The correct answer is C. Option C, negotiable between the seller or buyer and buyer's brokerage and broker. Explanation. Commissions, what the broker charges the seller, are always negotiable between the principal and the agent. They are not set by law with the Real Estate Commission, nor determined by the local group of brokers. Question 75. Commissions earned by a broker in a real estate sales transaction. Option A, are determined by agreement of the broker and his or her principal. Option B, are based on a schedule of commission rates set by the RI Real Estate Commission. Option C, is permitted to be shared with an unlicensed person, provided that such person aided the broker in bringing the buyer and seller together. Option D, is permitted to be deducted from the earnest money deposit and claimed by the broker as soon as the buyer and seller execute the purchase and sales agreement. The correct answer is A. Option are determined by agreement of the broker and his or her principal. Explanation. Commissions are always negotiable between the principal and the agent and are not determined by custom or law. Commissions may not be shared with an unlicensed party or deducted from the earnest money deposit. Question 76. All funds received by a broker on behalf of his or her principal is required to be deposited in an escrow or trust account within option of 5 working days of receiving the offer. Option B, 10 banking days of receiving all signatures. Option C, 3 days of obtaining all signatures for the contract. Option D, 3 days of receiving the offer. The correct answer is B. Option B, 10 banking days of receiving all signatures. Explanation. Our RI license law specifies that all earnest money must be deposited into a neutral account within 10 days of receipt by the listing broker. Common law application is 10 working or banking days. Question 77. A broker received an earnest money deposit from a buyer. Under our RI law, the broker should option immediately or by the next business day commingle the funds by depositing the earnest money in the broker's personal interest zero-bearing checking or savings account. Option B, deposit the money in an existing special escrow account in which all earnest money received from buyers is permitted to be held at the same time. Option C, hold the earnest money deposit in a secure place in the broker's real estate brokerage office until the offer is accepted. Option D, open a special escrow account that will contain funds for this transaction only, separate from funds received in any other transaction. The correct answer is B. Option B, deposit the money in an existing special escrow account in which all earnest money received from buyers is permitted to be held at the same time. Explanation. The broker may deposit this buyer's funds into an escrow account containing money from other customers and clients. The broker may not commingle the earnest money with another personal account nor keep it in the office indefinitely. Question 78. A broker received the buyer's earnest money check for $5,000 and immediately cashed it. At closing, the broker handed the seller a personal check drawn on his own bank account for $5,300, representing the original earnest money plus 6% interest. The broker option should have deposited the money in a special bank account and should have discussed the interest with the parties. Option B, should have deposited the money in a special non-interest bearing bank account. Option C, properly cashed the check, but should have kept the interest. Option D, should have deposited the money in his personal bank account and would have been entitled to keep the interest as a service fee. The correct answer is A. Option should have deposited the money in a special bank account and should have discussed the interest with the parties. Explanation. The money should have been deposited into a neutral account and the interest discussed with the parties. Our RI license law does not specify that escrow accounts must be interest-bearing nor to whom the interest must be payable. Question 79. If a broker establishes an account to hold money belonging to others, which of the following is correct? Option A. Accounts is permitted to be labeled either trust or escrow. Option B. The account cannot be in the same bank as the broker's personal checking account. Option C. An individual account is required for each transaction. Option D. All deposits into the account is required to solely be the assets of the broker's clients. The correct answer is D. Option D. All deposits into the account is required to solely be the assets of the broker's clients. Explanation. All deposits into the account must solely be the assets of the broker's clients. Our RI has no such requirement regarding the name on the account. Question 80. A broker manages 3 properties for the same owner. One property is in need of emergency repairs, but there is not enough money in the management account to cover the cost. The broker borrows money from the escrow account of one of the other properties to make the repairs. Which statement is true? Option A. Such action is proper when the same person owns all properties. Option B. The broker is required to use personal funds for repairs if there is not enough money in the management account. Option C. The broker is in violation of regulations for improperly handling escrow funds. Option D. The broker has acted properly by safeguarding the client's interest. The correct answer is C. Option C. The broker is in violation of regulations for improperly handling escrow funds. Explanation. The broker has violated state law by using funds from one property to make repairs on another property. Question 81. Under our real estate law, brokers and salespeople who are not lawyers is permitted to. Option is suggest additional language to be added to a pre-printed sales contract by a buyer or seller. Option B. Fill in blanks on pre-printed form contracts customarily used in their community. Option C. Explain the legal significance of specific pre-printed contract clauses to a buyer or seller. Option D. Complete the bill of sale after a sales contract has been signed. The correct answer is B. Option B. Fill in blanks on pre-printed form contracts customarily used in their community. Explanation. Brokers and salespeople are special agents, hired for a very narrow purpose, and should therefore be careful to avoid any appearance of the unauthorized practice of law. Filling in the blanks at the direction of the consumers who make final decisions and sign the contract is permissible and avoids any appearance of unauthorized practice of law. Question 82. All of the following is required to appear in a written listing agreement except option of the duration of the listing. Option B. The proposed gross sales price of the property. Option C. The complete legal description of the property being sold. Option D. A statement that a property is required to be shown to all prospective buyers regardless of race, color, religion, national origin, sex, handicap, or familial status. The correct answer is C. Option C. The complete legal description of the property being sold. Explanation. An adequate description, such as the property address, is required, but not the legal description. Listings must have an asking price and a definable broker fee to avoid an unintentional prohibited net listing. Question 83. A broker signs a listing agreement with a seller. The agreement contains the following clause. If the property has not been sold after 3 months from the date of the signing, this agreement will automatically continue for additional 3-month periods thereafter until the property is sold. Based on these facts, the agreement option is illegal in RI. Option B is illegal under RI law because it contains a reference to a specific time limit. Option C is legal under RI law because the list periods are for less than 6 months each. Option D automatically received the statutory 6-month listing period in RI. The correct answer is A. Option A is illegal in RI. Explanation. RI real estate license law requires that all listings must contain a definite termination date, month, day, and year. Automatic extensions are not permitted under RI law. Question 84. Regarding the listing agreements in RI, which of the following could result in the suspension or revocation of a licensee's license to practice real estate? Option A specified commission rate. Option B, no broker protection clause. Option C, no specific termination date. Option D, a specific termination date. The correct answer is C. Option C, no specific termination date. Explanation. Listings must have a defined termination date. Commission rates are required to avoid new listings. Question 85. Under RI law, the following disclosures is required to be included in a listing contract except option A, property condition. Option B, disposition of earnest money in the event of a purchaser default. Option C, seller's net return. Option D, special compensation. The correct answer is C. Option C, seller's net return. Explanation. A listing contract need not discuss the seller's net return. The buyer and seller must make the determination, and the broker may not disburse funds without their authority. Question 86. Upon obtaining the listing, a broker or licensed salesperson is obligated to: Option A, set up a listing file and issue it a number in compliance with RI real estate license law and rules. Option B, cooperate with every real estate office wishing to participate in the marketing of the listed property. Option C, place advertisements in the local newspapers. Option D, give the person or persons signing the listing a legible, signed, true, and correct copy. The correct answer is D. Option D, give the person or persons signing the listing a legible, signed, true, and correct copy. Explanation. A broker or licensed salesperson is obligated to give the person or persons signing the listing a legible, signed, true, and correct copy. State law does not obligate the listing broker to advertising, numbering files, or advertising by cooperating brokers. Question 87. A seller listed his house for sale with a broker on February 1. The listing agreement was to last 5 months. In April, the seller decided that the house was no longer for sale. Which statements is true? Option A. The seller has canceled the agreement and there are no mandated penalties. Option B. The RI Real Estate Commission will decide if the seller's action is justifiable. Option C. The seller has withdrawn the broker's authority to sell the property and is permitted to be subject to a penalty. Option D. The seller is required by law to leave his house on the market until June. The correct answer is A. Option A. The seller has canceled the agreement and there are no mandated penalties. Explanation. The listing agreement may be canceled, but the seller may be responsible for some expenses. The Real Estate Commission does not have jurisdiction in this matter. Question 88. A salesperson engaged in activities that constitute violations of the RI Fair Housing Law, including blockbusting and discrimination on the basis of disability. The salesperson also cashed a $25,000 earnest money check from a prospective buyer and used the proceeds to buy a new car. The salesperson's employing broker was unaware of all of these activities. Identify the impact on the salesperson's broker when the salesperson's violations are brought to the attention of the Real Estate Commission. Option A. The salesperson's employing broker will be required to pay any fine imposed against the salesperson out of his or her own personal funds. Option B. The employing broker will not have his or her license revoked as a result of the salesperson's violations. Option C. The salesperson's employing broker will be held liable for the RI Fair Housing violations only. Option D. The salesperson's actions are legally the responsibility of the employing broker, who will be subject to the same disciplinary action as the salesperson, regardless of whether or not he or she knew the violations had occurred. The correct answer is B. Option B. The employing broker will not have his or her license revoked as a result of the salesperson's violations. Explanation. Since the employing broker was unaware of the salesperson's illegal activities, there will be no action taken against the broker. Question 89. A person who believes that he or she has been illegally discriminated against is permitted to file a complaint with the Option A, Real Estate Commission. Option B, Board of Realtors Registered. Option C, RI Commission for Human Rights, or OHD. Option D, Attorney General. The correct answer is C. Option C, RI Commission for Human Rights, or OHD. Explanation. Fair housing complaints are generally directed to OHD or the RI Commission for Human Rights. Realtor registered organizations do not receive discrimination complaints. Question 90. Housing discrimination charge is required to be filed with the RI Commission for Human Rights within Option A, 2 years. Option B, 1 year. Option C, 30 days. Option D, 6 months. The correct answer is B. Option B, 1 year. Explanation. A person has 1 year to file a complaint with the RI Commission for Human Rights. Question 91. If a buyer wants to have a clause included in the sales contract under which the seller offers assurances against the existence of werewolves, vampires, and trolls on the property, which of the following statements is true in RI? Option A. The broker is permitted to include the clause because such standard supernatural disclosures are in general usage. Option B. In RI, brokers are permitted to add additional clauses to blank form contracts, such as the clause described here, that do not directly involve the conveyance of title to real property. Option C. Under RI law, a frivolous clause, such as the one described here, is not permitted, and any contract containing such a clause will be invalid. Option D. Only an attorney prepared and reviewed preprinted fill in the blank addendum or a licensed attorney prepared document of the clause is acceptable for inclusion in the sales contract. The correct answer is D. Option D. Only an attorney prepared and reviewed preprinted fill in the blank addendum or a licensed attorney prepared document of the clause is acceptable for inclusion in the sales contract. Explanation. Only an attorney can prepare actual legal clauses. Salespeople should be careful to avoid the unlawful practice of law by writing such a clause. Question 92. An RI real estate salesperson is permitted to lawfully collect compensation from Option A, either a buyer or a seller. Option B, any party to the transaction or the party's representative. Option C, a licensed real estate broker only. Option D, his or her employing broker only. The correct answer is D. Option D, his or her employing broker only. Explanation. Salespeople may only collect compensation from their employing brokers. Question 93. What are the procedures that a salesperson is required to follow when the salesperson decides to terminate his or her affiliation with an employing broker? Option A. Return his or her license along with a letter of termination to the RI Department of Business Regulation. Option B. Bear all customer cards to the employing broker. Option C. None. The broker is responsible for notifying the RI Department of Business Regulation of the change. Option D. Give the broker an official letter of termination that he or she can send to the RI Department of Business Regulation. The correct answer is C. Option C. None. The broker is responsible for notifying the RI Department of Business Regulation of the change. Explanation. The broker is responsible for notifying the RI Department of Business Regulation of the salesperson's departure and returning the salesperson's license to the department. If the salesperson is employed by another broker, the salesperson would submit a change of address request to the department. Question 94. A licensed salesperson is permitted to hold a concurrent license with more than one broker under which of the following circumstances? Option A. With the written consent of the brokers being represented. Option B. Under no circumstances. Option C. With the permission of his or her sales manager. Option D. With the permission of the Real Estate Commission. The correct answer is B. Option B. Under no circumstances. Explanation. A salesperson may be licensed with only one broker. Question 95. Several weeks after a closing, an associate broker received a thank you letter and a nice bonus check from the seller of the house. The associate broker cashed the check because he felt it was earned. In this situation, which of the following is true? Option A. The associate broker is permitted to accept the bonus because he is licensed as an associate broker. Option B. Accepting the money is a violation of our RI license law. Option C. The associate broker is permitted to accept the money if his broker perm is sent to do so. Option D. Accepting the money is allowed if more than 30 days have elapsed since the closing. The correct answer is B. Option B. Accepting the money is a violation of our RI license law. Explanation. A salesperson may collect a fee only from his or her employing broker. Question 96. When a sole proprietor has his or her license suspended for 2 years, what effect does this have on the associate brokers and salespeople affiliated with the proprietor? Option A. Affiliates' licenses will be revoked subject to reinstatement after 1 year. Option B. Affiliates' licenses will also be suspended for a 2-year period. Option C. Suspension has no effect on the affiliates. Option D. Affiliated licensees is required to find a new employing broker or return their licenses to the RI Department of Business Regulation. The correct answer is D. Option D. Affiliated licensees is required to find a new employing broker or return their licenses to the RI Department of Business Regulation. Explanation. The affiliates' licenses are on an active state until hired by a new broker. Question 97. A broker intends to open a branch office in a neighboring town. The broker applies for a branch office license, giving a name that clearly identifies its relationship with his main office. The broker names a licensed real estate salesperson as the branch office manager. Under these facts, will the broker receive approval for the branch office? Option A. No. The manager of a branch office is required to be a licensed real estate broker. Option B. No. Under the license law, brokers cannot have branch offices in more than one municipality. Option C. Yes, by naming the salesperson as the branch's manager, the broker is in compliance with the requirement that a broker is permitted to be in direct operational control of only one office or branch. Option D. Yes, the broker has fully complied with the requirement of the license law. The correct answer is A. Option A. No, the manager of a branch office is required to be a licensed real estate broker. Explanation. The broker will not receive permission. Brokers can have branch offices, but each office must be under the direction of a licensed real estate broker. Question 98. An associate broker is not satisfied with their present real estate company and has decided to become associated with another before the associate broker can begin actively selling for the new company. Option. A new broker is required to notify the commission of the change and send in the proper forms and fees. Option B. Associate broker is required to complete and send a change of address request, along with the proper fee, to the RI Department of Business Regulation. Option C. First broker is required to transfer the associate broker's license to the new office. Option D. Associate broker is required to take her license to the new brokerage and notify the commission within 3 days of the transfer to a new location. The correct answer is B. Option B. Associate broker is required to complete and send a change of address request, along with the proper fee, to the RI Department of Business Regulation. Explanation. The associate broker must complete and send a change of address request, along with the proper fee, to the RI Department of Business Regulation, and then the new license will be forwarded to the new broker. This license must be received before the associate broker can start selling. Question 99. When a licensed broker changes his or her place of business. Option of the new address is required to be approved by the board. Option B, his or her license is permitted to be revoked if the RI Department of Business Regulation is not notified. Option C, a new license will be issued for a full term. Option D, a new license will be issued by the board immediately. The correct answer is B. Option B, his or her license is permitted to be revoked if the RI Department of Business Regulation is not notified. Explanation. The RI Department of Business Regulation must be notified immediately of the new business address. Failure to do so may result in a revocation of the license. Question 100. In any real estate sales transaction that a broker negotiates, the broker is required to do the following except: Option A, make sure that the terms of the purchase and sales agreement have been carried out by both buyer and seller. Option B, keep copies of all documents involved in the transaction in his or her files for 5 years after the year in which the transaction was closed. Option C, inform the buyer of his or her personal opinion of the condition of the seller's title to the property. Option D, make sure that the written purchase and sales agreement includes all of the terms of the parties' agreement. The correct answer is C. Option C, inform the buyer of his or her personal opinion of the condition of the seller's title to the property. Explanation. The broker may not offer a title opinion, which could be an unauthorized practice of law. State law requires that these documents be retained for 5 years. Question 101. All of the following are necessary for a broker to be entitled to a commission except A. Option A, signed listing agreement. Option B, closing of title by the purchaser. Option C, binding contract between the seller and purchaser. Option D, ready, willing, and able buyer. The correct answer is A. Option A, signed listing agreement. Explanation. Simply having a listing agreement does not ensure a commission. Having a contract between a willing seller and a willing buyer and a closing of title by the purchaser generally lead to the broker receiving a commission. Question 102. Every RI real estate office is required to: Option A, employ at least one salesperson. Option B, display signage at the office location. Option C, maintain escrow account records for 5 years. Option D, keep transaction records for 3 years. The correct answer is D. Option D, keep transaction records for 3 years. Explanation. State law requires that brokers keep transaction records for at least 3 years. Question 103. Under the terms of a sales contract, a seller is required to provide a termite certificate. The seller requests that the salesperson order one. The salesperson does so, knowing she will receive a referral fee from the pest control company. Is this a violation of the license law? Option A, no, if the fee is less than $25. Option B, no, if the fee is disclosed either orally or in writing to the parties to the contract. Option C, yes, because the salesperson is permitted to not receive a referral fee. Option D, yes, because special fees is permitted to be paid to the salesperson only by the seller. The correct answer is C. Option C, yes, because a salesperson is permitted to not receive a referral fee. Explanation. A salesperson may not accept a fee from anyone other than his or her employing broker. Question 104. An airline pilot told a broker about some friends who were looking for a new home. The broker contacted the friends and eventually sold them a house. When is permitted to the broker pay the airline pilot for this valuable lead? Option A, as soon as a valid sales contract is signed by the parties. Option B, after the funds are released from escrow. Option C, only after the sale closes. Option D. The broker is permitted to not pay the pilot for the lead. The correct answer is D. Option D. The broker is permitted to not pay the pilot for the lead. Explanation. The broker may say thank you to the pilot, but may pay a referral fee only to someone who holds a real estate license. Question 105. A broker is convicted on May 1 of possession and distribution of a controlled substance. Both the crime and the conviction took place out of state. On June 15, the broker calls the Real Estate Commission and leaves a message informing the Real Estate Commission of the conviction. Based on these facts, which of the following is true? Option A. The broker has properly informed the RI Department of Business Regulation within 60 days after the conviction, and the broker's license is permitted to be renewed. Option B. Both the conviction and the broker's failure to immediately notify the RI Department of Business Regulation violates RI law. Option C. The conviction is evidence of both improper dealing and fraud. Option D. Because the conviction did not occur in RI, it is not evidence of unworthy conduct. The correct answer is B. Option B. Both the conviction and the broker's failure to immediately notify the RI Department of Business Regulation violates RI law. Explanation. Both the conviction and the broker's failure to immediately notify the RI Department of Business Regulation violates RI law. Question 106. A buyer has just entered into a contract to buy a condominium unit from a person who originally bought the unit from the developer and has lived there for the past 10 years. This new buyer has a right to cancel the contract within Option A. 5 days of receipt of resale documents. Option B. The new buyer does not have the right to cancel a signed contract in this situation. Option C. 15 days of receipt of resale documents. Option D. 5 days from the date the new executed the contract. The correct answer is B. Option B. The new buyer does not have the right to cancel a signed contract in this situation. Explanation. A buyer of a resale condo unit does not have any rescission rights. A buyer has the right to rescind the contract only when purchasing from the original developer and then within 5 days of receipt of contract. Question 107. How is a broker's commission determined in a real estate sales transaction? Option A. It is required to be stated in the listing agreement and is negotiated between the broker and seller. Option B. If under dispute, it will be determined through arbitration by the RI Department of Business Regulation. Option C. It is determined according to the standard rates set by agreement of local real estate brokers. Option D. It is required to be paid with cash or a cashier's check upon closing. The correct answer is A. Option A. It is required to be stated in the listing agreement and is negotiated between the broker and seller. Explanation. The broker and seller agree to the commission fee that must be stated on the listing agreement. There are no standard rates, nor is it determined by local custom. Question 108. A broker wants to list a property, but is getting a lot of competition from other brokers who also would like to list it. The broker offers the seller the following inducement to sign his listing agreement. I'll buy your property if it doesn't sell in 90 days. With this advertising, the broker is required to do the following except Option to buy the property at the agreed figure at any time during the 90 days. Option B. Show the seller written details of the plan before any contract of guarantee is signed. Option C. Market the property as if no special agreement existed. Option D. Show the seller evidence of the broker's financial ability to buy the property. The correct answer is A. Option to buy the property at the agreed figure at any time during the 90 days. Explanation. Since the ad says after 90 days, the broker is not obligated to buy it until the 90-day expiration. The broker must be able to substantiate his offer to purchase and must indicate all terms so that the seller is not surprised. Question 1. Under 9. A broker has obtained an offer to purchase a residence that is listed with his firm. After the buyers sign a purchase and sale agreement and the broker accepts the earnest money deposit, the broker is required to option deposit the earnest money in the broker's personal checking account for safekeeping until closing. Option B. Provide the buyers a copy of the agreement within 10 days as a receipt for their deposit. Option C. File the agreement in the broker's records and, when 2 or 3 other offers have been received for the property, present them all to the sellers, who then is permitted to choose the best offer. Option D. Complete the second earnest money agreement form that states an exaggerated selling price and give the second form to the buyers to present to the lender so that they will be certain to obtain sufficient financing for their purchase. The correct answer is B. Option B. Provide the buyers a copy of the agreement within 10 days as a receipt for their deposit. Explanation. The broker must provide the buyers a copy of the agreement within 10 days as a receipt for their deposit. All written offers must be presented to the seller immediately. Question 110. The listing agent is required to make a diligent effort to market which types of listings? Option A. Multiple listings and open listings. Option B. Exclusive right to sell listings and open listings. Option C. Exclusive right to sell listings and exclusive agency listings. Option D. Exclusive agency listings and open listings. The correct answer is C. Option C. Exclusive right to sell listings and exclusive agency listings. Explanation. Our RI license law specifies that all real estate contracts must be in writing. Furthermore, the listing agent must make a diligent effort to market all exclusive right to sell listings and exclusive agency listings. Question 111. A landlord has no pets policy in his apartment building. If a visually impaired person wants to rent an apartment from the landlord, but owns a guide dog, which of the following statements is true? Option A. The RI Fair Housing Law does not address the issue of guide, hearing, or support dogs. Option B. If the landlord's no pets policy is applied uniformly in a non-discriminatory manner, it is permitted to be legally applied to the guide dog as well. Option C. The RI Fair Housing Law specifically prohibits the landlord from refusing to rent the apartment to the visually impaired person on the basis of the owner's no pets policy. Option D. Under the RI Fair Housing Law, the landlord is permitted to not discriminate against the visually impaired person on the basis of a no pets policy, but the landlord is permitted to require the tenant to pay an additional damage fee. The correct answer is C. Option C. The RI Fair Housing Law specifically prohibits the landlord from refusing to rent the apartment to the visually impaired person on the basis of the owner's no pets policy. Explanation. The RI Fair Housing Law specifically prohibits the landlord from refusing to rent the apartment to the visually impaired person on the basis of the owner's no pets policy. Question 112. Under RI real estate law, the age of legal competence is: Option A, 20. Option B, 18. Option C, 21. Option D, 19. The correct answer is B. Option B, 18. Explanation. The age of legal competence in RI is 18. Question 113. All of the following are protected classes under the RI Fair Housing Law except: Option A, handicap. Option B, individuals addicted to controlled substances. Option C, race. Option D, sexual preference. The correct answer is B. Option B. Individuals addicted to controlled substances. Explanation. Individuals addicted to controlled substances have no protection under the RI Fair Housing Law. Question 114. Under RI real estate law, what is the statutory usury ceiling on loans secured by real estate? Option A, 10%. Option B, 15%. Option C, 22%. Option D, there is none. The correct answer is D. Option D, there is none. Explanation. Usury indicates an exorbitant interest rate, and thus usury ceilings have been abolished. Question 115. Unclaimed estates issued to the state after a period of Option A, 10 years. Option B, 5 years. Option C, 20 years. Option D, 15 years. The correct answer is C. Option C, 20 years. Explanation. Unclaimed estates issued to the state after a period of 20 years. Question 116. A childless couple has entered into a purchase and sale agreement with the seller. In accordance with the RI lead hazards law, the couple has a lead paint inspection done on the property, and lead paint is discovered. Is any action required of the owner to keep the sale progressing? Option A. No, abatement of lead paint is required only in rental housing. Option B. No, as long as the sellers do not have an elevated blood lead level, they need not conduct any abatement. Option C. No, abatement of lead paint is required as the couple is childless. Option B. Yes, they is required to abate defective lead paint. The correct answer is D. Option D. Yes, they is required to abate defective lead paint. Explanation. In RI defective lead-based paint must be abated. Question 117. How long before the signing of a sales contract for recreational lots outside RI is required to the seller present a purchaser with a prospectus? Option A. Within 72 hours. Option B. 1 week. Option C. 5 business days. Option D. 24 hours. The correct answer is A. Option A. Within 72 hours. Explanation. The seller must present a purchaser with a prospectus within 72 hours before the signing of a sales contract for recreational lots outside RI. Question 118. All of the following persons or entities is permitted to serve as the trustee of the trust deed loan in RI except in Option an attorney. Option B, title insurance company. Option C, real estate broker. Option D, saving and loan association. The correct answer is C. Option C, real estate broker. Explanation. The real estate broker may not serve as trustee of a trustee loan, a savings loan association, title insurance company, or an attorney may serve as a trustee. Question 119. Which statement or title search methods commonly used by an attorney in RI? Option A, title search and opinion. Option B, foreign certificates. Option C, certificates of title. Option D, land court certificates. The correct answer is A. Option A, title search and opinion. Explanation. Title search and opinion are used, but land court certificates, certificates of title, and torrent certificates are not used. Question 120. Under RI real estate law, the responsibility for preparing any promissory notes involved in a closing belongs to the option A, seller's broker, option B, buyer, option C, settlement attorney, option D, lender. The correct answer is D. Option D, lender. Explanation. The lender is responsible for preparing any promissory notes. Question 121. A sales contract is signed on May 1. Closing takes place on June 10, and the deed of trust is recorded on June 15. A borrower's first payment is due on August 30. When is the earliest date on which the broker can receive his or her commission check? Option A, May 1. Option B, June 10. Option C, June 15. Option D, August 30. The correct answer is C. Option C, June 15. Explanation. The broker receives the commission check when the deed is recorded and funds are disbursed, in this example, June 15. Question 122. Under RI real estate law, who is responsible prior to closing for calculating the proration between the buyer and seller, searching the title, and preparing the mortgage note and deed? Option A, salesperson. Option B, lender. Option C, closing attorney. Option D, broker. The correct answer is C. Option C, closing attorney. Explanation. The closing attorney is responsible for these activities. Question 123. A broker or salesperson is permitted to perform the following in preparation for the closing except: Option A, explain closing procedures to both buyer and seller and anticipate decision-making alternatives. Option B, coordinate inspections and deliver documents and escrow monies to the appropriate attorney. Option C, conduct any title searches that might be required. Option D, maintain a time schedule and provide net data. The correct answer is C. Option C, conduct any title searches that might be required. Explanation. The broker will not conduct a title search that may lead to charges of practicing law without a license. The broker can maintain a time schedule, provide net data, explain closing procedures, anticipate decision-making alternatives, coordinate inspections, and deliver documents and escrow monies to the appropriate attorney. Question 124. How old is required to a citizen of RI before he or she is permitted to prepare a legally binding will? Option A, 15, as long as real property is not involved. Option B, any age as long as the will is legally witnessed and recorded. Option C, 21. Option D, 18. The correct answer is D. Option D, 18. Explanation. The age of majority is 18. Question 125. Identify how many witnesses is required to sign in the presence of the person making their will to fulfill the legal minimum. Option A, 4. Option B, 2. Option C, 3. Option D, 1. The correct answer is B. Option B, 2. Explanation. 2 witnesses must sign in the presence of the person making the will. Question 126. Which statement legal life estate could be available to a surviving husband in RI? Option A, homestead. Option B, a marital easement. Option C, courtesy. Option D, dower. The correct answer is A. Option A. Homestead. Explanation. Only a homestead life estate is available to a surviving husband in RI. Courtesy and dower are no longer recognized. Question 127. The principal method of delineating property boundaries or legal descriptions in RI is known as the Option A. System of metes and bounds. Option B. System of principal meridians and baselines. Option C. Colonial block grant system. Option D. Rectangular survey system. The correct answer is A. Option A. System of metes and bounds. Explanation. The primary method of describing property in RI is through the system of metes and bounds. Question 128. A homeowner contracted with a B.C. construction company to put a new deck on her house. They began work on May 1 and finished on June 1, but they were never paid. On July 1, the homeowner sold her house to a buyer who received a mortgage loan from Country Bank and a mortgage loan from Citibank. Citibank recorded its mortgage on July 1. Country Bank recorded its mortgage on July 2. A B.C. construction company records a mechanics lien on July 3. Identify the priority of the liens. Option A. Citibank, Country Bank, B.C. construction. Option B. A.B.C. construction, then Citibank and Country Bank equally. Option C. A.B.C. construction, Citibank, Country Bank. Option D. Citibank and Country Bank equally in A.B.C. construction. The correct answer is C. Option C. A.B.C. construction, Citibank, Country Bank. Explanation. The mechanic has 120 days to file the lien, which is effective as of the date construction was completed, or the last significant visit. Thus, the mechanic is first, then the mortgage company is as recorded. Question 129. Once a judgment is rendered, a creditor on a judgment is required to enforce it within Option A. 20 years. Option B. 6 months. Option C. 5 years. Option D. 1 year. The correct answer is A. Option A. 20 years. Explanation. A creditor must enforce a judgment within 20 years. Question 130. Under RI real estate law, an individual is permitted to enter into legally enforceable contracts, with no exceptions when he or she reaches the age of Option A. 18. Option B. 21. Option C. 19. Option D. 16. The correct answer is A. Option A. 18. Explanation. Legal age with no exceptions is 18. Some exceptions may enable a 16-year-old the right to sign certain contracts. Question 131. If a minor enters into a contract in RI, what is the statutory period within which he or she is permitted to legally void the contract after reaching the age of majority? Option A. 6 months. Option B. The contract is permitted to be voided only up to the day when the minor reaches the age of majority. After that date, the contract is binding. Option C. There is no statutory period. Option D. 1 year. The correct answer is C. Option C. There is no statutory period. Explanation. A contract signed by a minor may be voided at any time in the future. Question 132. Under RI real estate law, the prescriptive period to acquire an easement is Option A. 30 years. Option B. 12 years. Option C. 100 months. Option D, 10 years. The correct answer is D. Option D, 10 years. Explanation. In Rye, the prescriptive period to acquire an easement is continuous, open, and notorious use established for 10 years. Question 1. 133. A neighbor has been crossing W's property to get to a state beach. W wishes to prevent the neighbor from acquiring an easement to cross his land. To do so effectively, W can: Option A, write her a letter forbidding her to cross the property. Option B, write the neighbor a letter granting her permission to cross the property. Option C, put up a no trespassing sign. Option D, follow RI statutory procedures. The correct answer is D. Option E, follow RI statutory procedures. Explanation. W must follow statutory procedures. Writing a letter or putting up a no trespassing sign may be insufficient. Question 134. The prescriptive period in the state of RI to acquire title to real property to adverse possession is: Option A, 10 years. Option B, 12 years. Option C, 7 years. Option D, 15 years. The correct answer is A. Option A, 10 years. Explanation. Continuous use, hostile to the owner, must be established for at least 10 years to acquire title by adverse possession. Question 135. A neighbor does a 10-foot easement through W's forested lot for the purpose of walking to the bank of the river. The neighbor widens the path to 14 feet to accommodate his truck so he can launch his boat. W is furious. Which statement is true in this situation? Option A. The new use is hostile, and if not stopped within 10 years, it could become an easement by prescription. Option B. If the neighbor uses the extension for 20 years, then the original easement is automatically used by adverse possession. Option C. The additional 4 feet is a reasonable extension of the original easement and is required to be granted. Option D. The neighbor's original use was a right. W can do nothing. The correct answer is A. Option A. The new use is hostile, and if not stopped within 10 years, it could become an easement by prescription. Explanation. The new use is hostile, and if not stopped within 10 years, could become an easement by prescription. Question 136. With respect to leases for terms in excess of 1 year, the landlord is permitted to record, instead of the actual lease, say: Option A, rent supplement notice. Option B, notice of lease. Option C, notice of constructive occupancy. Option D, list pendants. The correct answer is B. Option B, notice of lease. Explanation. The landlord may record a notice of lease. Question 137. A couple has signed a lease containing a provision to waive their rights to the interest earned from the security deposit. This provision is: Option A, unenforceable, thus making the lease invalid. Option B, enforceable because all parties agreed to it. Option C, unenforceable only for the term of the lease. Option D, unenforceable, but the lease is still valid. The correct answer is B. Option B, enforceable because all parties agreed to it. Explanation. The provision is enforceable since all parties agreed to it. In our RI law, interest earned on security deposits is not addressed, and the lease is still valid. Question 138. Under our RI real estate law, the landlord is permitted to file court action for eviction for non-payment of rent if the tenant fails to pay rent within how many days of the scheduled due date? Option A, 10 days. Option B, 20 days. Option C, 7 days. Option D, 30 days. The correct answer is B. Option B, 20 days. Explanation. With proper notice, the landlord may file court action for eviction 20 days after the failure to pay on the due date. The 20 days includes the 15 days for the late rent payment plus the 5 days for the demand notice period. Question 139. In a month-to-month periodic lease, how long is required to a landlord wait before he or she can raise rents? Option A, 6 months. Option B, forever, because this is illegal. Option C, until all the leases expire. Option D, 30 days. The correct answer is D. Option D, 30 days. Explanation. The landlord may raise rents after a 30-day notice of the rent increase. Question 140. A tenant leased space in a warehouse and put down a 2-month security deposit. What % interest does her security deposit earn as long as she does not pay her rent late? Option A, 5.25%. Option B, 2%. Option D, 4%. The correct answer is C. Explanation. The RI Landlord-Tenant Act does not specify who is entitled to accrued interest from security deposit accounts, nor does it specify an interest rate for those accounts. In common practice, the landlord accrues the interest on such accounts at whatever rate they can obtain. Question 141. Under RI real estate law, if a monthly rental payment is made 10 days after the due date, how much interest is required to the tenant forfeit on his or her security deposit? Option A, 2 months security deposit interest. Option B, 1 month security deposit interest. Option C, 3 months security deposit interest. Option D, there is no penalty to the tenant in this case. The correct answer is D. Option D, there is no penalty to the tenant in this case. Explanation. The RI Landlord-Tenant Act does not provide a penalty for overdue rent. According to the Act, the landlord must wait 15 days after the due date before the rent is legally overdue. Question 142. A tenant skips out on his less scheduled monthly payment on a 1-year lease. The landlord is permitted to Option extend the lease automatically because the tenant gave no notice. Option B, retain the security deposit. Option C, keep the tenant's belongings. Option D, do nothing because the lease is terminated. The correct answer is B. Option B, retain the security deposit. Explanation. The landlord may, at his or her option, retain the security deposit for unpaid rent. Under REALTA, the landlord must return security deposits upon termination of the rental agreement within 20 days of receipt of a forwarding address from the ex-tenant. Question 143. Under summary process, if an evicted tenant does not remove his or her belongings, the belongings of the evicted tenant is permitted to be Option A, used by the landlord. Option B, brought to the town dump. Option C, sold by the landlord. Option D, placed in storage by the sheriff. The correct answer is D. Option D, placed in storage by the sheriff. Explanation. The sheriff may place the belongings in storage. Question 144. If no one claims the proceeds of a sale resulting from a public auction of the belongings of an evicted tenant within 30 days from such sale, these proceeds are turned over to the Option B, sheriff who executed the eviction. Option B, town treasury. Option C, state's general fund. Option D, landlord to offset the judgment. The correct answer is D. Option D, landlord to offset the judgment. Explanation. The proceeds of the sale may be turned over to the landlord to offset the judgment. Question 145. How is required to a landlord handle a security deposit? Option A. Landlords is required to pay tenants interest on their security deposits. Option B. Security deposits can be used only for residential units. Option C. Unless there have been damages, the landlord is required to return the security deposit to the tenant within 20 days of the end of the lease. Option D. At the end of the lease, the landlord cannot apply the security deposit to rent owed by the tenant. The correct answer is C. Option C. Unless there have been damages, the landlord is required to return the security deposit to the tenant within 20 days of the end of the lease. Explanation. Unless there have been damages, the landlord must return the security deposit to the tenant within 20 days of the end of the lease. Security deposits may be required for the rental of any kind of property. Question 146. One landlord owns a 3-unit apartment building. Another is the landlord of a 30-unit apartment building. Based on these facts, which of the following is true of security deposits? Option A. Both landlords are required to pay interest on security deposits at a rate linked to minimum deposit passbook savings accounts at RI's largest commercial bank. Option B. Both landlords is required to give tenants an itemized statement of alleged damages before they can withhold any part of the security deposit as compensation. Option C. Only the landlord of the 3-unit building is required to limit security deposits to 3 months' rent. Option D. Only the landlord of the 3-unit building is required to give tenants an itemized statement of alleged damages for any part of the security deposit is permitted to be withheld as compensation. The correct answer is B. Option B. Both landlords is required to give tenants an itemized statement of alleged damages before they can withhold any part of the security deposit as compensation. Explanation. All residential building owners are required to give tenants an itemized statement. Security deposits are limited to 1 month's rent. Question 147. The tenant is defaulted this lease for failing to pay rent on time. Under RI real estate law, how much written notice is a landlord required to give the tenant to pay overdue rent prior to filing a court action to evict? Option A. 10 days. Option B. 0 years. Option C. 3 days. Option D. 5 days. The correct answer is D. Option D. 5 days. Explanation. RI law requires that a 5-day demand notice be given to the tenant after the rent is 15 days in arrears. Question 148. In order to enforce the provisions of a lease, the lease. Option A would have to be in writing for a term that begins 1 year after the date of signing. Option B would have to be in writing for any time period less than 6 months. Option C can be oral for up to 15 months after the date of signing. Option D, that is verbally agreed to for 18 months, could be enforceable. The correct answer is A. Option A would have to be in writing for a term that begins 1 year after the date of signing. Explanation. The statute of frauds requires all contracts to be in writing to be enforceable in a court of law. One exception to this rule is that an oral lease of 1 year duration or less is generally considered to be enforceable. Question 149. Under our real estate law, if a landlord wants to terminate a year-to-year tenancy, how much notice is required to the tenant receive? Option A, 30 days. Option B, 90 days. Option C, 4 months. Option D, 7 days. The correct answer is B. Option B, 90 days. Explanation. The landlord must give a 90-day notice to terminate a year to your tenancy. Question 150. A landlord who is subject to the Residential Landlord and Tenant Act charges $750 per month for an apartment. Identify the maximum amount the landlord can require as a security deposit. Option A, $1,000. Option B, $2,250. Option C, $1,500. Option D, $750. The correct answer is D. Option D, $750. Explanation. The landlord can require up to 1 month's rent as a security deposit. In this example, $750. Question 151. During a crime wave, a tenant decides to install a burglar alarm in a rented house. Does the tenant need to inform the landlord? Option A, yes, but the tenant is required to also give the landlord instructions and passwords. Option B, no, because only tenants in multi-unit apartment buildings are required to inform a landlord about a security system. Option C, yes, but the cost of the system is permitted to be deducted from the rent. Option D, no, because the tenant has full right of possession during the lease. The correct answer is A. Option A, yes, but the tenant is required to also give the landlord instructions and passwords. Explanation. The tenant must notify the landlord and supply instructions and passwords. Question 152. After a lease terminates, the tenant is entitled to the return of his or her security deposit. Option A, with no deduction withheld. Option B, within 3 weeks including interest. Option C, unless the property has been transferred to a new owner. Option D, within 20 days after notification of the tenant's forwarding address. The correct answer is D. Option D, within 20 days after notification of the tenant's forwarding address. Explanation. The security deposit must be returned within 20 days of notification of the tenant's forwarding address. Question 153. How soon is required to deeds of conveyance be recorded after closing? Option A, 1 business day. Option B, 1 month. Option C, 3 business days. Option D, by reasonable time. The correct answer is D. Option D, a reasonable time. Explanation. Deeds should be recorded within a reasonable time after closing. Question 154. Under our real estate law, the local official who records deeds and maintains the grantor of the grantee list is the Option A, tax collector. Option B, town clerk. Option C, first selectman. Option D, assessor. The correct answer is B. Option B, town clerk. Explanation. The town clerk records deeds and maintains the grantor of grantee lists. Question 155. To be eligible for recording in RI, a document is required to be Option A, acknowledged. Option B, witnessed by 2 persons who are not affected by the document. Option C, drawn up by an attorney. Option D, in any language. The correct answer is A. Option acknowledged. Explanation. To be eligible for recording in RI, the document must be acknowledged and in English. Question 156. To acquire title to the land, a tax sale purchaser. Option A files a tax certificate with the Registry of Deeds. Option B registers the deed to the property at the Registry of Deeds. Option C pays the back taxes and files a tax release at the Registry of Deeds. Option D brings action in the land court to register title and confirm ownership. The correct answer is D. Option D brings action in the land court to register title and confirm ownership. Explanation. The tax sale purchaser must bring action in the land court to register the title and to confirm ownership. Question 157. The homeowner's property is being foreclosed through a strict foreclosure process. The homeowner has the right to redeem the property by Option A redeeming the property within 1 year of titles passing to the foreclosing creditor. Option B matching the successful bidder's bid within 1 year of the foreclosure sale. Option C redeeming the property before title passes to the foreclosing creditor. Option D being the successful bidder at the foreclosure sale. The correct answer is C. Option C redeeming the property before title passes to the foreclosing creditor. Explanation. The homeowner has the right of equity of redemption before title passes to the foreclosing creditor. Question 158. Under RI real estate law, if an owner defaults on his or her mortgage loan and the property is ordered sold at a foreclosure sale, the owner is permitted to redeem the property. Option after the sale, under the statutory right of reinstatement. Option B prior to the sale, under the equitable right of redemption. Option C after the sale, under the statutory right of redemption. Option D prior to the sale, under the statutory right of redemption. The correct answer is B. Option B prior to the sale, under the equitable right of redemption. Explanation. The homeowner has the right of equity of redemption before title passes to the foreclosing creditor. Question 159. If there is no redemption of the property, how long is required to a tax sale purchaser wait before starting action to obtain title to the land? Option A. 2 years after the unpaid taxes are due. Option B. 2 years from the date of the tax sale. Option C. 1 year and 1 day from the date of the tax sale. Option D. 3 years from the date of the tax sale. The correct answer is C. Option C. 1 year and 1 day from the date of the tax sale. Explanation. A tax sale purchaser must wait 1 year and 1 day from the tax sale before starting action to obtain title to the land. Question 160. How long is the defaulted borrower's redemption period after a foreclosure sale is complete? Option A. There is no redemption period. Option B. 6 months. Option C. 3 years. Option D. 1 year. The correct answer is A. Option A. There is no redemption period. Explanation. There is no redemption period after a foreclosure sale. Question 161. The RI statutes require a complete revaluation of real properties in any given town once every. Option A. 10 years. Option B. 5 years. Option C. 12 years. Option D. The grand list increases by 10%. The correct answer is A. Option A. 10 years. Explanation. State statutes require revaluation of real property every 10 years. Question 162. From a strictly legal standpoint, real property taxes become a lien on the property as of Option A, date of foreclosure, suit is filed and recorded. Option B, date of assessment. Option C, due date. Option D, 30th day from the due date. The correct answer is C. Option C, due date. Explanation. Taxes become delinquent on the due date and become a lien on the property at that time. Question 163. The conveyance tax levied by the state on the seller of the property is based on the Option A, selling price. Option B, date of the purchase. Option C, earnest money. Option D, amount of the mortgage. The correct answer is A. Option A, selling price. Explanation. The conveyance tax is based on the sale price. Question 164. How is required to the real property transfer tax be paid? Option A, by purchasing transfer tax stamps from the county recorder. Option B, by certified check made out to the Housing Development Authority. Option C, by purchasing a green sheet from the county recorder for the total due. Option D, by personal check made out to the Department of Revenue. The correct answer is A. Option A, by purchasing transfer tax stamps from the county recorder. Explanation. Transfer tax stamps must be purchased from the county recorder to pay this tax. Question 165. General real estate taxes apply to which of the following? Option A, federal government buildings. Option B, private schools. Option C, cemeteries. Option D, housing owned by a disabled veteran. The correct answer is D. Option D, housing owned by a disabled veteran. Explanation. A disabled veteran will have to pay tax on his or her house. Cemeteries, federal government buildings, and private schools are exempt from paying general real estate taxes. Question 166. How often is the assessed valuation of all real estate in RI adjusted by town authorities? Option A, every 3 years. Option B, quarterly. Option C, every 10 years. Option D, biannually. The correct answer is C. Option C, every 10 years. Explanation. Town authorities must adjust the assessed valuation of real property every 10 years. Question 167. Under our real estate law, real estate taxes become a lien on the property on Option A, July 1. Option B, December 31. Option C, June 30. Option D, January 1. The correct answer is D. Option D, January 1. Explanation. RI taxes are assessed on December 31. They become a lien on January 1. Question 168. In order to pay the current year's real estate taxes in one payment without having to pay a penalty and interest on the taxes is required to be paid by Option A, June 20 of the next year. Option B, July 1 of the next year. Option C, January 1 of the current tax year. Option D, January 1 of the next year. The correct answer is C. Option C, January 1 of the current tax year. Explanation. Taxes must be paid by January 1 of the current tax year to avoid penalties and interest on the taxes. Question 169. Under RI real estate law, a reduction in real property taxes for a personal residence is permitted to be available to which of the following individuals? Option A, 34-year-old widower. Option B, 26-year-old single parent. Option C, 55-year-old retiree. Option D, 28-year-old veteran. The correct answer is D. Option D, 28-year-old veteran. Explanation. RI real estate tax laws permit real estate property tax exemptions for bona fide veterans. After applying for the exemption and meeting the veteran qualification requirements, the veteran gets a set exemption amount, regardless of years of military duty. Question 170. A recently recorded deed states that the purchase price was $10 and other good and valuable consideration. The conveyance tax stamp indicates that $192.50 was paid for town conveyance tax. What was the property sold for? Option A, $21,175. Option B, $87,490. Option C, $192,500. Option D, $175,000. The correct answer is B. Option B, $87,490. Explanation. The RI state mandated real estate transfer tax rate is $2.20 per $1,000 of sale price. Since the recorded tax is stated as $192.50, then the other good and valuable consideration would have to have been valued at $87,490. Question 171. The state wishes to widen a highway. It exercises its right of eminent domain and takes a portion of the property through condemnation proceedings. In this situation, the conveyance tax would be: Option A, $250, regardless of the consideration amount. Option B, the same as usual, but picked up by the state. Option C1, half the usual. Option D, 0. The correct answer is D. Option D, 0. Explanation. There is no conveyance tax on a condemnation sale. Question 172. Identify the RI transfer tax on a property that sells for $250,000. Option A, $550. Option B, $1,250. Option C, $125. Option D, $250. The correct answer is A. Option A, $550. Explanation. The RI state mandated real estate transfer tax rate is $2.20 per $1,000 of the sales price. $250 equals $250 if $2.20 equals $550. Question 173. Identify the state transfer tax on a property that sells for $185,000. Option A, $1,850. Option B, $37. Option C, $185. Option D, $407. The correct answer is D. Option D, $407. Explanation. The RI state mandated real estate transfer tax rate is $2.20 per $1,000 of the sales price. $185,000 divided by $1,000 equals 185x $2.20 equals $407. Question 174. A house was purchased for $203,000 cash. How much will the revenue stamps cost? Option A, $945. Option B, $927. Option C, $900. Option D, $446. The correct answer is D. Option D, $446. Explanation. The RI state mandated real estate transfer tax rate is $2.20 per $1,000 of the sales price. $203,000 divided by $1,000 x 2.20 equals $446. Question 175. A house was sold for $150,000 with the buyers assuming the $40,000 mortgage. How much will the revenue stamps cost? Option A, $344. Option B, $506. Option C, $242. Option D, $330. The correct answer is D. Option D, $330. Explanation. The RI state mandated real estate transfer tax rate is $2.20 per $1,000 of the sales price. $150,000 divided by 1,000 times $2.20 equals $300. Question 176. If an aggrieved person is awarded a judgment against a real estate licensee for violation of the RI license law, which of the following correctly states the aggrieved person's rights regarding the recovery fund? Option A. He or she has the right to seek satisfaction from the licensee in a private civil action after being compensated from the recovery fund. Option B. He or she has the right to a $10,000 maximum recovery from the recovery fund, plus limited court costs and attorney's fees. Option C. He or she has the right to a maximum award amount of $50,000 per licensee involved from the recovery fund, including court costs and attorney's fees. Option D. He or she has the right, under the license law, to immediately apply to the writer for payment from the recovery fund for the full judgment amount plus court costs and attorney's fees. The correct answer is C. Option C. He or she has the right to a maximum award amount of $50,000 per licensee involved from the recovery fund, including court costs and attorney's fees. Explanation. He or she has the right to a maximum award amount of $50,000 per licensee involved from the recovery fund, including court costs and attorney's fees. Question 177. If a broker violates the license law, following a lawsuit resulting in monetary damages to a consumer, what is the latest date upon which the injured party is permitted to file for a collection from the real estate recovery fund? Option A. 3 years after the date on which a professional relationship of trust and accountability commenced. Option B. 3 years after the judgment was awarded. Option C. 2 years after the alleged violation occurred. Option D. 1 year after the judgment was awarded. The correct answer is D. Option D. 1 year after the judgment was awarded. Explanation. The injured party may file for a collection from the real estate recovery fund within 1 year after the judgment was awarded. Question 178. Which is the purpose of the RI Real Estate Recovery Fund? Option A. To protect the Commission from claims by individuals that they have suffered a monetary loss as the result of the action of a licensee who has violated the license law or committed other illegal acts related to a real estate transaction. Option B. To provide an interest-generating source of revenue to fund the activities of the Commission. Option C. To ensure that real estate licensees have adequate funds available to pay their licensing and continuing education fees. Option D. To provide a means of compensation for actual monetary losses suffered by individuals as a result of the acts of a licensee who violates the license law or commits other illegal acts related to a real estate transaction. The correct answer is D. Option D. To provide a means of compensation for actual monetary losses suffered by individuals as a result of the acts of a licensee who violates the license law or commits other illegal acts related to a real estate transaction. Explanation. The purpose of the RI Real Estate Recovery Fund is to provide a means of compensation for actual monetary losses suffered by individuals as a result of the acts of a licensee who violates the license law or commits other illegal acts related to a real estate transaction. Question 179. Of the following, who is permitted to receive compensation from the RI Real Estate Recovery Fund? Option A. Any unrelated party suffering damage from the actions of a licensee. Option B. Cooperating broker who does not receive a commission split. Option C. Broker who does not receive an earned commission. Option D. Buyer who pays a fee to a broker under a buyer agency agreement. The correct answer is A. Option A. Any unrelated party suffering damage from the actions of a licensee. Explanation. Any unrelated party suffering damage from the actions of a licensee is eligible to receive compensation from the fund. Question 180. The maximum compensation that will be paid from the RI Real Estate Recovery Fund for any single transaction is: Option A. $50,000 per licensee involved. Option B. $550,000 per licensee involved. Option C. $5,000 per licensee involved. Option D. $10,000 per licensee involved. The correct answer is A. Option A. $50,000 per licensee involved. Explanation. The maximum compensation will be paid from the RI Real Estate Recovery Fund for any single transaction is $50,000 per license involved. Question 181. Whenever the Commission is required to satisfy a claim against a licensee with money from the RI Real Estate Recovery Fund, the option aggrieved party is permitted to later collect additional damages by forcing the sale of any property newly acquired by the defendant licensee. Option B. Licensee is permitted to continue engaging in real estate activities under the Commission's direct supervision. Option C. Licensee is required to thereafter pay $25 per year into the account when applying to renew his or her license. Option D. Licensee is permitted to repay the full amount plus interest to the account if his or her license is to be reinstated. The correct answer is D. Option D. Licensee is permitted to repay the full amount plus interest to the account if his or her license is to be reinstated. Explanation. If the Commission has satisfied a claim against the licensee by paying out of the fund, the licensee must repay the full amount plus interest to the account if his or her license is to be reinstated. Question 182. Identify the minimum balance of the RI Real Estate Recovery Fund. Option A. $450,000. Option B. $550,000. Option C. $250,000. Option D. $350,000. The correct answer is C. Option C. $250,000. Explanation. The minimum balance of the RI Real Estate Recovery Fund is $250,000. Question 183. After proper investigation, a payment is made from the RI Real Estate Recovery Fund as a result of the improper activities of a licensee. What happens when the payment is made? Option A. The licensee is subject to a fine of $2,000. Option B. No further action is taken. Option C. The licensee's license is automatically revoked. Option D. The license of the licensee is automatically suspended. The correct answer is C. Option C. The licensee's license is automatically revoked. Explanation. Once a payment is made from the fund, the licensee's license is automatically revoked until the money is repaid plus interest. Question 184. A broker commits a fraudulent act in connection with the sale of a property on March 15, 1999. On March 30, the transaction closes. On November 1, the client sues the broker, alleging fraud. On December 20, the jury finds in favor of the client. When is required to the client file a claim with the Real Estate Commission to recover money from the recovery fund? Option A. The request is required to be filed within 30 days following the illegal activity, in this case, by April 15, 1999. Option B. Within 1 year of filing suit, in this case, by November 1, 2000. Option C. Within 2 years of the date of closing, in this case, by March 30, 2001. Option D. Within 1 year after having been awarded a judgment by the courts, in this case, by December 20, 2000. The correct answer is D. Option D. Within 1 year after having been awarded a judgment by the courts, in this case, by December 20, 2000. Explanation. The client must file a claim within 1 year after having been awarded a judgment by the court, in this case, December 20, 2000. Question 185. Under our real estate law, dower and courtesy are: Option A, recognized voluntarily. Option B, not recognized. Option C, currently recognized. Option D, recognized but not in force. The correct answer is B. Option B, not recognized. Explanation. RI does not recognize courtesy and dower. Question 186. All of the following forms of ownership are recognized under RI law except: Option A, tenancy in common. Option B, survival. Option C, joint tenancy with survivorship rights. Option D, tenancy by the entireties. The correct answer is B. Option B, survival. Explanation. RI does not recognize a form of ownership called survival. It does recognize tenancy in common, joint tenancy with survivorship rights, and tenancy by the entireties. Question 187. A husband and wife who own their home as tenants by the entireties obtain a divorce. At that time, the tenancy be the entireties. Option A, reverts to common interest ownership. Option B, continues until one of them dies. Option C, extinguishes and becomes a tenancy in common. Option B, extinguishes and becomes a tenancy at sufferance. The correct answer is C. Option C, extinguishes and becomes a tenancy in common. Explanation. Tenancy by the entireties extinguishes upon the divorce and converts to tenancy in common. Question 188. To establish a marketable record title, an unbroken chain of title is required to be established for a period of at least: Option A, 40 years. Option B, 15 years. Option C, 20 years. Option D, 60 years. The correct answer is A. Option A, 40 years. Explanation. To establish a marketable record title, an unbroken chain of title must be established for a period of at least 40 years. Question 189. How far back does a normal RI title search go? Option A, 75 years. Option B, 15 years. Option C, 40 years. Option D, 125 years. The correct answer is C. Option C, 40 years. Explanation. A normal RI title search goes back 40 years. Question 190. Unless stated to the contrary, in a deed, ownership of land by a married couple in RI is assumed to be by Option A, tenancy by the entirety. Option B, joint tenancy. Option C, tenancy in common. Option D, severalty. The correct answer is B. Option B, joint tenancy. Explanation. Unless stated to the contrary in the deed, ownership of land by a married couple in RI is assumed to be by tenancy in common. Question 191. A buyer enters into a purchase and sale contract to buy a house on October 15. The closing occurs on November 15, at which time the seller delivers the deed. The deed is recorded on November 17. The buyer moves into the property on November 18. Under RI real estate law, title would have passed from the seller to the buyer on Option A, November 15. Option B, November 18. Option C, October 15. Option D, November 17. The correct answer is A. Option A, November 15. Explanation. Title will have passed from seller to buyer on November 15, the time that the seller delivered the deed to the buyer.